Timberline Court was the kind of street where the grass got measured. Not eyeballed, measured. 2.5 inches, no higher, per Article 4, Section 4.1 of the Brookstone Ridge Homeowners Association's Declaration of Covenants, Conditions, and Restrictions. On the morning of March 14th, the grass had nothing to do with what was about to happen. This time it was a trailer. Rachel Doyle was standing in her own driveway at 1847 Timberline Court, Fairview, Ohio, with her arms folded and her jaw set, in front of a 14-foot flatbed utility trailer loaded with pressure-treated lumber, a portable ramp jig, and 2 coils of galvanized railing. The trailer belonged to Patriot Build Co., the small non-profit her husband ran on weekends and drill leave, the one that built free wheelchair ramps for disabled veterans who couldn't afford contractors and couldn't wait 6 months for a VA grant to clear. It had been parked there for 11 hours. According to Section 9.4 of the CC&Rs, that was 10 hours and 59 minutes too many. 2 men were walking up the driveway wearing navy polo shirts embroidered with a shield logo that said Ironclad Compliance Solutions, laminated badges clipped to their belts, and the particular swagger of men who had never once in their lives been asked to show identification and back it up. The taller one, sunburned and thick through the neck, was already pulling a photo out of a clipboard folder. The shorter one had a toe strap slung over one shoulder like a bandolier. "Ma'am, we're with Brookstone Ridge Compliance, and this vehicle is in violation," the tall one said. His name, as Rachel would later learn from a subpoenaed employment file, was Wade Pruitt. "We've got authorization to remove it. It's not a vehicle, it's a trailer, and it's leaving at 6 tonight," Rachel said. "It's for a ramp build, for a disabled vet 2 streets over. Take a picture of the trailer, not my house, and go file whatever you need to file. Ma'am, step back from the trailer. This is my driveway." It had not, in fairness, come out of nowhere. This was the 3rd time in 11 months a laminated badge had shown up at 1847 Timberline Court. The first had been over a basketball hoop left 6 inches into what Ironclad's paperwork called the setback zone, a violation Rachel had resolved by moving the hoop 4 feet, on her own, within the hour. No fine assessed, no confrontation. The second had been a warning. Not even a citation, just a warning, hand-delivered by Denny Osick alone, about a holiday wreath left on the door 2 days past the association's published removal deadline of January 6th, a deadline that existed, as far as anyone could tell, purely so that Gary Draper's newsletter would have something small and petty to report on in the slow post-holiday news cycle. Rachel had taken the wreath down that same afternoon and thought, at the time, that this was simply what living in a place like Brookstone Ridge cost you. Small, irritating taxes on your patients, paid in exchange for matching mailboxes and a pond you weren't allowed to fish in. The trailer was different, and Rachel had told Wade Pruitt exactly why, twice, in the 11 hours before he shoved her. She had told him on the phone, when Meridian's automated fine notice first came through, that the trailer belonged to a registered 501 Sleet 3 nonprofit, that it would be gone within 24 hours of its arrival, well inside any reasonable reading of Section 9.4, even before the retroactive fine was applied, and that her husband, who could personally verify all of this, was unreachable on a training rotation until Friday evening. She had told him again, standing in her own driveway 40 minutes before the assault, when Pruitt and Osick first pulled up, and she came out to meet them before they could knock, hoping a calm, in-person explanation would end things the way it had ended things twice before. It did not end things. Wade Pruitt had, in fact, already decided the outcome of the visit before he got out of the truck, a decision Rachel could not have known was shaped less by Section 9.4 of the Brookstone Ridge CC&Rs than by a line item on an invoice Ironclad Compliance Solutions submitted to Meridian Community Management every 2 weeks, one that paid Wade Pruitt and Denny Osick 30 cents on every dollar of every fine their 2-man operation successfully closed out. A trailer removed under threat, with the homeowner's compliance documented on a clipboard, closed out clean. A trailer photographed and left alone pending a phone call to a husband on a training exercise did not. Wade Pruitt did not know, standing in that driveway with a tow strap over his shoulder, that the math he was running in his head, dollars per closed violation, minutes per stop, stops per day, was about to be entered into a criminal court record under a different heading entirely: motive. What happened next took 4 seconds, and it would be described in 3 different ways by 3 different witnesses, but the version that mattered, the one captured in high definition by the Ring doorbell camera mounted 11 feet away, the one that would eventually be entered into evidence as State's Exhibit 6, showed Wade Pruitt reaching past Rachel to unhook the trailer's safety chain. Rachel putting her hand flat against his chest to stop him, and Wade Pruitt shoving her backward with enough force that she caught the trailer's fender with her hip, spun, and hit the concrete driveway with her forearm and the side of her face. Her lower lip split against her own teeth. A neighbor 3 doors down would later testify she heard the sound from her kitchen window and thought, at first, that someone had dropped a bag of mulch. Rachel Doyle did not know, in that moment, on her hands and knees on a driveway in Fairview, Ohio, with blood in her mouth and a stranger's laminated badge glinting 6 inches from her face, that the video from her own front door had already backed itself up to a cloud server, time-stamped and untouchable. She did not know that her husband, Master Chief Petty Officer Marcus Doyle, United States Navy, retired 11 months earlier, after 22 years, and 4 combat deployments with a naval special warfare team, was 40 minutes from home, driving back early from a veterans fundraiser because he'd had a feeling, the kind of feeling a man develops after 2 decades of paying attention to feelings, that he needed to check on his wife. She did not know any of that yet. All she knew was that a man wearing a costume of authority had just put his hands on her over a lumber trailer, and that somewhere in the next several months, an entire town was going to learn exactly what that mistake was going to cost. Drop your city, and tell me, do you live in an HOA? I want to know how many of you are watching this from behind enemy lines right now, because trust me, this story is about to get a lot worse before it gets better. 6 months earlier, Brookstone Ridge looked, to the untrained eye, like the kind of subdivision that ends up on a real estate brochure, with the word prestige in the name. 211 homes arranged in a loose grid of cul-de-sacs and crescents around a man-made pond nobody was allowed to fish in, a clubhouse that hosted exactly 4 events a year, and an entrance sign carved from Indiana limestone that had cost the association $38,000 in 2019 and was still being paid off through a special assessment line item that nobody on the board could fully explain. It was the kind of place where every mailbox matched, every garage door was the same shade of cotton whisper white, and every homeowner had, at closing, signed a 61-page CC&R document they had been assured, by a smiling real estate agent, that nobody actually enforced. Rachel and Marcus Doyle had bought the house at 1847 Timberline Court in the spring of 2021, back when Marcus was still active duty and home only in stretches, and Rachel, a physical therapist at Fairview Regional Medical Center, had picked the neighborhood because of the schools and the quiet, and the fact that it was 11 minutes from the hospital. She liked the quiet. She would come, in time, to understand that quiet in Brookstone Ridge was not peace. It was surveillance, with the volume turned down. The house itself was a modest 2-story colonial, with navy shutters, a color the association's own paint palette, Exhibit C, attached to the CC&Rs, listed as harbor slate, and approved without qualification. A 2-car garage, and a backyard that backed onto a shared greenbelt, where, on the rare Sunday Marcus was home, he taught the neighbor kids how to throw a proper spiral. Rachel had grown up in a rental duplex in Dayton, the daughter of a single mother who worked double shifts at a diner, and buying a house with a limestone entrance sign and a homeowners association had felt, at 28, like proof of something. She would tell a reporter, months later, that this was the detail she kept coming back to. Not the fine, not even the assault, but the particular grief of watching a symbol of having made it get twisted into a mechanism for being made small. Marcus had grown up 2 states over, in a town in West Virginia small enough that everyone in it had watched him leave for boot camp at 18, and, 22 years and 4 deployments later, had thrown him a homecoming parade down the town's single main street when he retired as a Master Chief. He did not talk about the deployments, not with neighbors, not on camera, not in the one interview he agreed to give, not out of secrecy, but out of the plain, practiced discipline of a man who understood that some rooms don't need those stories in them. What he would say, when asked directly what 2 decades of special warfare taught him that a suburban HOA dispute could possibly need, was this: you learn to gather information before you act. You learn that the loudest guy in the room is rarely the most dangerous one, and you learn that paperwork wins more fights than people think. Brookstone Ridge had a rhythm to it that Rachel had learned to read within her first year. The clubhouse newsletter, 4 pages, mailed monthly at a cost the association listed as $1,100 a year, ran a recurring column called Keeping Up Appearances that named, by street, if not always by full address, homeowners cited for violations that month. It was Gary Draper's column. He wrote it himself, under the byline, The Board, and it had, over 6 years, become the neighborhood's most read piece of literature, less for its content than for the collective, low-grade dread of wondering whose lawn would appear in it next. Cheryl Anholt's garden gnomes had made the column twice. Priya Nandakumar's original ramp application, before it was denied, had been referenced in a spring edition under the header, Reminder, all structural modifications require prior board approval, without her name, though everyone on Larkspur Bend knew exactly whose modification it meant. Draper ran unopposed for board president in 4 of his 6 years, and in the 2 years he technically had a challenger, the challenger, in both cases, homeowners who had grown frustrated enough to file the paperwork, withdrew before the vote, citing, in one case, personal reasons, that a departing board member later admitted, off the record, were actually a quiet, informal warning from Draper's allies that a challenger's own compliance record would receive closer attention going forward. Nothing about this was illegal on its face. It did not need to be illegal to be effective. It only needed to be exhausting enough that people stopped trying, and for 6 years, in Brookstone Ridge, it had been. Ironclad Compliance Solutions had, by the time it reached the Doyle's driveway, already visited 8 other homes over the preceding 10 months, a pattern nobody at the time had connected, because nobody outside the board had access to the invoices that would eventually reveal the shape of it. Wade Pruitt and Denny Osick drove a white pickup with a magnetic door sign, wore the same navy polos to every visit, and had developed, over those 10 months, a script. Knock, cite the section number, hold up the clipboard, ask for immediate compliance, and, if a homeowner pushed back, invoke board authorization, as though the phrase itself carried legal weight, which, under any actual reading of Ohio's Planned Community Act, it did not. Most homeowners, faced with 2 men in matching shirts holding a clipboard, simply complied. It is worth pausing on that, because it is the entire mechanism this story is built on. Authority, in a subdivision like Brookstone Ridge, rarely needs to be real. It only needs to look real for exactly as long as it takes someone to back down. The board president was a man named Gary Draper, 58 years old, semi-retired from a mid-tier insurance brokerage, and the kind of person who introduced himself at neighborhood functions as basically the mayor of Brookstone Ridge, which he found funnier than anyone else did. Draper had been board president for 6 consecutive years, an accomplishment made possible by the fact that Brookstone Ridge elections were held on weeknights in January, required a physical presence or a notarized proxy to vote, and were never, under any circumstances, publicized more than 9 days in advance. All of it technically compliant with the association's bylaws. All of it engineered by a man who understood that apathy was the best incumbency protection money could buy. In the spring of 2023, Draper had signed a 3-year vendor agreement with a company called Ironclad Compliance Solutions, LLC, a community standards enforcement partner that promised to handle CC&R inspections, violation documentation, and, this was the phrase buried in Section 4 of the contract, on-site remediation of non-compliant conditions when homeowners are unresponsive or unavailable. Ironclad was not a licensed towing company. It was not bonded as a property management enforcement agency, a distinction that matters enormously under Ohio law and matters even more under the Davis-Sterling framework that governs similar disputes out west, where courts have been explicit that a homeowners association has no inherent police power and cannot delegate authority it never possessed in the first place. Ironclad Compliance Solutions, LLC, was, in point of fact, 2 guys named Wade Pruitt and Denny Osick who had met at a gun range, printed some polo shirts, and convinced Gary Draper, who badly wanted an enforcement arm that made problems disappear instead of drag through a slow, embarrassing complaint process, that they were exactly what Brookstone Ridge needed. Marcus Doyle had missed most of this. He'd been in and out on training rotations, then transitioning out of the Navy, then getting Patriot Build Co. off the ground, a nonprofit he'd started with 2 former teammates to build free ADA-compliant wheelchair ramps for disabled veterans stuck on wait lists. He knew Draper vaguely, the way you know the guy who waves too hard at the mailbox. He knew there'd been some letters about the lawn, about a flag bracket that was 2 inches taller than code, about the color of a storm door. He had filed those letters, mentally, under not worth the fight, which, as it turned out, was a mistake plenty of people in Brookstone Ridge had made before him, and one Gary Draper had learned to count on. Now that you know Rachel and Marcus Doyle, has your HOA ever pulled something that made your blood boil? Tell me the single worst thing your HOA has ever done, because I guarantee you it's not going to top what's coming. The trailer itself was almost an afterthought. Patriot Build Co. had been awarded a project for a Marine Corps veteran named Eldon Frey, 71 years old, who lived 2 streets over on Larkspur Bend and had been navigating 3 concrete steps to his front door in a wheelchair for the better part of a year, because the VA contractor list in the county was backed up past October. Marcus and his 2 teammates, a former corpsman named Tobias Doc Reyes and a retired chief named Alan Vance, had planned to prep materials in the Doyle's driveway on a Thursday and deliver everything to Frey's house Friday morning. The trailer arrived Wednesday evening. Marcus left for a 2-day training refresher with his old unit's alumni network Thursday at 4 a.m., expecting to be back by Friday night to finish the delivery, and told Rachel, almost as an afterthought, if anybody says anything about the trailer, just tell them it's for the Frey ramp, it's gone Friday. Anybody did say something. On Thursday at 11:14 a.m., a notice appeared on the Doyle's front door. Not mailed, not emailed, hand-delivered, and taped directly to the storm door glass, in violation of the association's own notice procedures under Section 12.2, which required mailed notice with a minimum 5-day cure period for a first violation. The notice cited Section 9.4, no trailer, boat, recreational vehicle, or commercial equipment trailer shall be parked, stored, or permitted to remain on any lot, driveway, or street for a period exceeding 24 hours, and assessed an immediate fine of $50 per day, retroactive to the hour the trailer had arrived, a retroactive penalty that, notably, appeared nowhere in the association's published fine schedule, which Rachel would later find in the association's own records, capped first offense trailer violations at $25 per day with a mandatory 72-hour cure window. Rachel called the HOA's management office. She got a voicemail. She called Gary Draper's personal cell, which was listed, absurdly, on the community Facebook group as the direct line for board concerns. Draper picked up on the fourth ring, listened for 11 seconds, and said, "Ma'am, I hear you, but the rules are the rules for everybody, and if I make an exception for a trailer, I've got 15 other homeowners calling me by Saturday." Rachel explained, again, that the trailer belonged to a non-profit building a ramp for a disabled veteran, that it would be gone by Friday afternoon, that her husband, who was, at that exact moment, 4 hours away doing land navigation drills with men who had once pulled wounded teammates out of buildings under fire, could not personally come remove it before then. Draper's response, recorded nowhere, but remembered precisely by Rachel for the rest of her life, was, "That's not really my problem. I'll have compliance handle it." Compliance arrived at 4:40 p.m. on Friday, 40 minutes after Rachel got home from a half-day shift at the hospital, in the form of Wade Pruitt and Denny Osick, and a laminated badge that said, "Community Standards Officer," in a font that had been chosen, deliberately, to resemble a municipal code enforcement badge, right down to the eagle graphic clip-arted off a stock photo site. Nothing about ironclad compliance solutions had any legal authority to remove private property from private property, tow a trailer, enter a driveway without consent, or lay a single finger on a homeowner who told them to leave. Ohio Revised Code is unambiguous on this point, and it would become the single most quoted statute in the entire case that followed. None of that mattered to Wade Pruitt at 4:43 p.m. on a Friday, standing over a woman with a split lip on her own driveway, holding a tow strap he had no legal right to attach to anything. $50 a day, retroactive, undocumented, in violation of the association's own fine schedule, against a woman whose husband was building a free wheelchair ramp for a disabled veteran. Is this legal where you live? What would you have done if two strangers showed up at your house with fake badges and a tow strap? Rachel Doyle got up off her driveway with the help of the neighbor who'd heard the fall, a retired schoolteacher named Cheryl Anholt, who came out in her socks and immediately started screaming at Wade Pruitt, in a tone that suggested 31 years of managing 8th graders had prepared her for exactly this moment. Cheryl called 911. The Fairview Police Department arrived 9 minutes later, at which point Wade Pruitt and Denny Osick were sitting in their truck in the street, having decided, correctly, that assaulting a homeowner on video was not covered in whatever training they'd never had. Rachel was taken to Fairview Regional, her own hospital, where 2 of her co-workers were on shift, with a fractured left wrist, 4 stitches above her eyebrow, and a chipped incisor. The responding officer, a 14-year veteran of the department, named Sergeant Dana Okafor, took one look at the ring footage on Cheryl Anholt's phone and told Rachel, flatly, "Ma'am, that's assault. That's not a civil matter. That's a criminal charge, and I'm writing it up as one." Marcus got the call from Cheryl Anholt, not from Rachel, who was, by then, on painkillers and being wheeled toward radiology, at 5:52 p.m., 4 hours before he'd planned to be home. He would later say that the drive back took the longest 90 minutes of his life, longer than any deployment, longer than the 26 hours he'd once spent pinned down outside a compound in a country he still can't name in interviews. What he remembers most clearly is not fear. It was the specific, focused, terrifyingly calm feeling he'd been trained to recognize in himself for 2 decades. The feeling that meant a problem had just become a mission, and missions get planned, not felt. He arrived at Fairview Regional at 7:15 p.m. His wife's arm was in a temporary splint, her lip swollen, a butterfly of stitches above her eyebrow. He sat with her for 11 minutes without saying a word, holding her uninjured hand, and then he asked her one question. "Do you know their names?" She did. They'd been standing close enough to read. By 8 p.m., sitting in the hospital parking lot, Marcus Doyle had already pulled up the Ohio Secretary of State's business filing database on his phone and searched Ironclad Compliance Solutions LLC. He found it registered 11 months earlier, listing a single member, Wade R. Pruitt. No professional bond, no state contractor's license, no registration as a debt collector, property manager, or towing operator. All classifications that Ohio law would have required for any of what Ironclad claimed to be doing on the Brookstone Ridge Board's behalf. He found the vendor contract Draper had signed because it turned out Ohio's Planned Community Act requires HOA contracts over a certain threshold to be disclosed to homeowners on request, and Marcus requested it that same night, in writing, by certified mail, citing the statute by number. That was the first move in what would become, over the following 4 months, one of the most thoroughly, patiently, devastatingly documented campaigns any HOA board in the state of Ohio had ever been on the receiving end of. And it started, like a lot of Marcus Doyle's professional life had started, with a plan written on a legal pad at a kitchen table at 11 o'clock at night, while his wife slept upstairs with her arm in a cast. Marcus called Alan Vance and Tobias Reyes before he called anyone else, not because he needed muscle. Nobody in this story, in the end, needed muscle. A distinction Marcus was careful to make explicit every time a reporter or a comment section tried to turn this into a story about a scary man intimidating a scared board, but because he needed a second and third set of eyes that thought the way he thought, methodically, skeptically, and without patience for anyone's assumed authority. Doc Reyes, the former corpsman, had spent 2 decades assessing situations under pressure and knew, instinctively, how to build a timeline nobody could later dispute. Alan Vance had run logistics for their old unit and could organize a paper trail the way most people organize a grocery list. Between the 3 of them, over the next 6 weeks, they built a case file that would eventually run to over 400 pages, cross-referenced, dated, and, this detail mattered enormously later, never once altered or added to after the fact, because Marcus knew that the first thing a defense attorney does with a civilian's evidence file is look for the seam where something got added in hindsight, and he was determined never to give one. The days immediately after the assault were the hardest, and the narrator will not pretend otherwise for the sake of pacing. Rachel Doyle, a woman who spent her professional life helping other people rebuild strength after injury, spent 2 weeks unable to lift a coffee mug with her left hand, unable to chew on the left side of her mouth, and unable, this was the part she talked about least, in the one interview she ever gave, to walk out to her own driveway without her pulse spiking. She took 8 days of medical leave from Fairview Regional. Her supervisor, when she explained why, went quiet for a long moment and then said, "I had a guy from an HOA in Coldwater Ridge threaten to lien my parents' house over a shed. I believe every word of this." Gary Draper's first public response at the regularly scheduled Brookstone Ridge board meeting on March 19th, 5 days after the assault, held in the clubhouse's community room with 11 homeowners present, a quorum requirement of 15 technically unmet but proceeded with anyway, was to describe the incident as an unfortunate miscommunication between a resident and a compliance contractor, and to note, for the minutes, that the association bears no liability for the actions of independent contractors. He did not mention that Ironclad's contract, Section 7-B, explicitly indemnified the association only in cases where Ironclad acted within the lawful scope of its authorized duties, a scope that did not, under any reading of Ohio law, include laying hands on a homeowner. He did not mention that he had personally directed Ironclad to handle the trailer situation without cure period, without proper notice, and in direct violation of the association's own governing documents. Marcus Doyle, sitting in the back row with his wife's hospital discharge paperwork in a folder on his lap, said nothing that night. He listened. He took notes. He filmed the meeting, legally, under Ohio's one-party consent recording law, and he thanked Draper for his time on the way out, which unsettled Draper considerably more than shouting would have. Marcus Doyle just filed a certified records request citing the Ohio Planned Community Act by statute number, instead of confronting Gary Draper directly at the meeting. Right call. Or should he have gone in swinging? What's your strategy? What followed, over the next 3 weeks, was not a fight in the way Brookstone Ridge was used to fights. A screaming match at a mailbox, a nasty thread in the community Facebook group, a lawyer's letter that got ignored. It was reconnaissance, and Marcus Doyle ran it the way he'd run every operation for 2 decades. Quietly, methodically, and with a plan that assumed the other side would eventually notice and try to destroy the evidence. He started with the public record. Ohio requires homeowners associations of a certain size to file annual reports, and, in cases involving fines exceeding certain thresholds, to maintain a written fine schedule available to all members on request. A document Gary Draper had for 6 years, treated as a state secret. Marcus requested it, in writing, citing the exact statute. When the management company, a 2-person outfit called Meridian Community Management that handled bookkeeping and mailers for 11 small associations in the county, including Brookstone Ridge, took 19 days to respond, well past the 10-business-day window Ohio law allowed, Marcus filed a formal complaint with the state and copied Draper on it. He requested board meeting minutes going back 3 years. What came back, heavily redacted in a way that itself became evidence, showed a pattern. Ironclad compliance solutions had been dispatched to 8 other properties in the previous 10 months, always to homeowners who had, at some point, publicly criticized Draper, at a meeting, in the Facebook group, or in an email. Cheryl Anholt, the neighbor who'd called 911, had been fined $600 the previous summer over a garden gnome collection Draper found unbecoming of the neighborhood aesthetic, a fine with no corresponding provision anywhere in the CC&Rs, because there is no CC&R provision in America governing garden gnomes, a detail that, when it later surfaced on the local news, generated more outraged comments than the assault itself. A single mother 2 streets over, named Priya Nandakumar, had been fined $1,200 over a wheelchair ramp, a real one, for her own son, that Draper's board had initially rejected before quietly approving it 11 days later, after the fines had already stacked up, without ever refunding them. Marcus found something else, buried in an invoice Meridian's bookkeeper had, evidently, not thought anyone would ever cross-reference. Ironclad Compliance Solutions was being paid not a flat contract rate, but a percentage, 30%, of every fine it successfully collected on the association's behalf, which meant that every fine Wade Pruitt and Denny Osick wrote, every trailer they showed up to handle, every homeowner they intimidated into paying rather than fighting, went directly into their own pockets. It was not, technically, illegal on its face. HOAs across the country structure vendor contracts in strange ways, but it created, in black and white, a financial incentive for 2 men with laminated fake badges to manufacture violations, escalate confrontations, and collect as aggressively as possible, and it directly contradicted the sworn statement Gary Draper had given to the Fairview Police Department 3 weeks earlier, in which he described Ironclad as a flat-fee vendor with no financial stake in individual violations. That statement, made to a police officer investigating a felonious assault, was a lie Draper had told under the specific and mistaken belief that no one would ever see the invoices behind it. Marcus did not, at any point in this process, threaten anyone. He did not raise his voice at a single meeting. Old teammates who watched him work during this period, men who had seen him under actual gunfire, would later say, half joking and half not, that this was scarier. Marcus doesn't get loud when something's wrong, said Alan Vance, his Patriot Build co-founder, in the one interview he agreed to give a local reporter months later. Marcus gets organized. That's when you should be worried. The escalation, when it came from Draper's side, and it came the way it usually does, not with an apology, but with a lean. On April 2nd, 3 weeks after the assault, Rachel Doyle received a certified letter from Meridian Community Management informing her that her account was $2,850 in arrears. The accumulated trailer fines, retroactive, at $50 a day, plus a $200 administrative processing fee and a threatened $75 hearing scheduling fee for a compliance hearing she had never been formally notified of. The letter warned that failure to remit payment within 30 days would result in the association filing a lien against 1847 Timberline Court under Ohio's HOA lien statute, a lien that, left unresolved, could ultimately lead to foreclosure, a legal mechanism that exists in nearly every state in the country and has, in fact, cost more than one American family their home over unpaid fines smaller than a car payment. The letter arrived the same week Rachel's wrist came out of its temporary splint and went into a hard cast for 6 more weeks. Her physical therapy job, the job where she spent her days teaching other people how to regain use of injured limbs, now required her to work one-handed, and her supervisor quietly shifted her caseload to lighter patients while she healed, an accommodation Rachel was deeply grateful for and deeply humiliated to need. The community, predictably, took sides before it took facts. The Brookstone Ridge Facebook group, 640 members, moderated, not coincidentally, by Gary Draper's sister-in-law, filled with posts suggesting Rachel had provoked the confrontation, that the Doyles were always parking work equipment everywhere, that, if you don't want fines, follow the rules like everybody else. A neighbor Rachel had once brought a casserole to during a rough patch stopped waving at her in the driveway. Someone left a printed flyer on the Doyles' door, unsigned, folded in half, listing every alleged violation the household had ever received, including the flag bracket and the storm door color, under the header, "Know Your Neighbors." Rachel, who had grown up believing that being the reasonable, quiet, rule-following person in any room was a form of protection, learned in the space of 3 weeks that in a corrupt system, being reasonable simply meant you got run over more slowly. There was a specific comment on the Facebook group that Rachel would return to more than any other in the months that followed, not because it was the cruelest, but because it was the most revealing. A man named Kurt Belanger, who lived on the far side of the pond and had never so much as spoken to Rachel in 3 years, wrote, "Maybe if her husband was actually home instead of playing soldier every other week, this wouldn't happen." The comment received 19 likes before Cheryl Anholt, uninvited and unasked, screenshotted it, printed it, and mailed it, along with a copy of Marcus's DD 214 discharge summary, which Rachel had given her permission to share specifically for this purpose, to every board member individually, with a handwritten note that said only, "Read this twice before you decide what kind of neighborhood you want to be." Kurt Belanger deleted the comment 4 days later. He did not, notably, apologize. The lien threat did something to Rachel that the assault itself, oddly, had not. It made her angry instead of afraid. She had spent the first 2 weeks after the driveway, flinching at the sound of truck doors closing on the street, waking at 2 a.m., certain she'd heard footsteps on the porch, asking Marcus, more than once, to check that the deadbolt was thrown on a door that had never once in 3 years been left unlocked. But a letter threatening to take her house, the actual walls around her actual life, over a wrongly calculated $2,850 she did not owe, did not frighten her. It clarified something. She told Marcus, the night the certified letter arrived, sitting at the kitchen table with her cast propped on a folded towel, "I am done being the reasonable one in this house. I want to see their books." Marcus, who had already spent 3 nights quietly building exactly that plan on a legal pad she hadn't yet been shown, said only, "Good, because I already started. $2,850. Retroactive. Undocumented. Against a woman with a fractured wrist from an assault the association's own vendor committed on her driveway. Is this legal where you live? What would you have done in Rachel's position? Marcus's answer to the lien threat was not a lawyer's letter, although one of those was coming. It was, first, a phone call to a woman named Denise Okonkwo Barrett, an attorney who ran a small practice in Columbus, specializing almost exclusively in HOA disputes and consumer protection cases. A specialty she had built, she told Marcus, in their first 15-minute consultation, because I got tired of watching decent people get bullied by their own neighbors' committees. Denise took one look at the vendor contract, the redacted meeting minutes, the fine schedule discrepancy, and the doorbell camera footage, and told Marcus something he would repeat, almost word for word, at a board meeting 6 weeks later. This isn't a civil dispute anymore. This is a criminal assault, a fraudulent debt collection scheme, and a board president who just lied to a police officer in a sworn statement. You don't need one lawsuit. You need 3. The fight-back phase, which is the part of this story most viewers write in asking for, the part where the machine gets dismantled, did not happen in one dramatic scene. It happened over 5 weeks, on 4 fronts, simultaneously, and it is worth walking through all 4, because the 4 fronts are the actual reason Brookstone Ridge changed, and not, contrary to what the eventual news segment implied, because one Navy SEAL was scary. Front 1 was criminal, Sergeant Dana Okafor's assault report, backed by ring footage that showed unambiguous physical contact initiated by Wade Pruitt against a non-threatening homeowner on her own property, went to the Fairview County Prosecutor's Office within the first 2 weeks. Wade Pruitt was charged with assault, a first-degree misdemeanor under Ohio law, given Rachel's injuries met the threshold for physical harm, and, once investigators pulled the ironclad business filings and cross-referenced Pruitt's badge against actual municipal code enforcement credentials, a charge of impersonating a public official adjacent authority was added, based on the deliberate visual similarity of the laminated badge to legitimate code enforcement identification, a charge Ohio prosecutors do not bring often, but do bring, and one that made the local news desk sit up in a way the assault charge alone had not. Sergeant Okafor's own investigation, running in parallel, turned up a detail that made the eventual plea negotiations considerably less friendly for Wade Pruitt than they otherwise might have been. This was not his first documented use of physical force while wearing the ironclad polo. A homeowner in a neighboring subdivision, outside Brookstone Ridge entirely, a separate association that had also, unrelated to Draper, hired Ironclad on a short-term trial basis the previous winter, had filed a police report 8 months earlier alleging that Pruitt had grabbed his arm hard enough to bruise it during a dispute over a basketball hoop. That report had gone nowhere at the time, filed and quietly closed for lack of corroborating evidence, because there had been no ring camera, no split lip, and no fractured wrist to put in front of a prosecutor. Sergeant Okafor pulled it anyway, attached it to Rachel's case file as evidence of pattern and intent, and made a point of telling Marcus, the day she found it, this is exactly why documentation matters. The first guy nobody believed. Your wife, they can't not believe. Front 2 was regulatory. Marcus and Denise filed a formal complaint with the Ohio Attorney General's Consumer Protection Section, laying out, in a 31-page document with exhibits, the pattern of retroactive fines outside the published schedule, the improperly noticed violations, the undisclosed contingency fee arrangement with Ironclad, and Draper's false statement to police about that arrangement. The Attorney General's office does not investigate every HOA complaint that lands on its desk. Most years, thousands come in, and a fraction get real attention. But a complaint attached to a police assault report, a documented lien threat against an injury victim, and a financial kickback structure is the kind of complaint that gets a case number fast. It got one. An investigator named Priscilla Odom was assigned within 9 days. Priscilla Odom's first call to Marcus lasted 40 minutes, and Marcus would later describe it as the first conversation since the assault where he felt like he was talking to someone whose job was simply to find out what was true, without an angle. She asked for the invoices. She asked for the redacted meeting minutes and, separately, requested the unredacted originals directly from Meridian Community Management under her office's subpoena authority, a request Meridian's owner, a harried woman named Denise Kowalczyk, who ran the company essentially by herself out of a strip mall office and had never wanted any part of Gary Draper's arrangement with Ironclad in the first place, complied with inside of 48 hours, visibly relieved, by her own later admission, to finally have somewhere official to hand the problem to. What came back confirmed everything Harold Vance and Marcus had already pieced together on their own, and added one detail neither of them had found. Draper had personally approved 3 separate Ironclad invoices in the 6 weeks before the assault that listed compliance remediation, occupied structure, as the line item, a euphemism, Priscilla Odom noted dryly in her eventual report, for exactly the kind of physical, on-site confrontation that had put Rachel Doyle in an emergency room. Front 3 was civil. Denise Okonkwo Barrett filed suit on Rachel's behalf against Ironclad Compliance Solutions LLC, Wade Pruitt individually, and this was the part that made Gary Draper stop returning Meridian's calls, the Brookstone Ridge Homeowners Association itself, on a theory of negligent hiring and breach of fiduciary duty. Ohio law, like the law in nearly every state, holds HOA boards to a fiduciary standard. Board members are legally obligated to act in the association's and its members' best interest, with reasonable care, and a board that hires an unlicensed, unbonded enforcement contractor with a financial incentive to escalate confrontations, and does so without any vetting, is a board that has a very hard time arguing it exercised reasonable care once a homeowner ends up in an emergency room. Denise structured the complaint in a way she explained to Rachel and Marcus over coffee at her office, deliberately, sentence by sentence, so neither of them would go into a deposition surprised by their own case. The negligent hiring claim rested on the fact that no board member, including Draper, had ever requested proof of licensing, bonding, or insurance from Ironclad before signing a 3-year vendor agreement, a failure that would have taken, Denise pointed out, roughly the same amount of effort as looking up a restaurant on a health inspection website. The breach of fiduciary duty claim rested on something colder. The invoices showed that Draper had continued approving Ironclad's contingency payments for 6 weeks after the assault, even as he was telling homeowners at the March 19th meeting that the matter was under review, which meant the board president had known, in real time, exactly how the enforcement arm he'd hired was compensated, and had kept cutting the checks anyway. Rachel asked Denise, during that same coffee meeting, whether the lawsuit was really about money, and Denise told her something Rachel repeated often afterward. The money is how the system says sorry when it can't say it any other way. But you're not doing this for the settlement. You're doing it so the next Ironclad thinks twice before it takes the contract. The lawsuit also, without either Rachel or Marcus explicitly asking for it, became a magnet for other homeowners. Within a month of the filing becoming public record, Denise's office had fielded calls from 6 other Brookstone Ridge residents describing their own encounters with Ironclad. None as severe as Rachel's, but each one a data point in the same pattern. A man on Fenwick Circle, who'd been threatened over a basketball hoop and paid a $150 fine rather than argue. A couple on Larkspur Bend, unrelated to Priya Nandakumar, fined $400 over a temporary above-ground pool their insurance company had actually required them to fence, a fence Ironclad had cited as its own separate violation 2 weeks later. And an elderly widow on Cobblestone Lane who had simply paid every fine Ironclad ever handed her, totaling nearly $2,000 over 10 months, because, as she told Denise's paralegal over the phone, "I didn't think I was allowed to say no to them." That sentence, more than any invoice or contract clause, was the one Denise read aloud, verbatim, in her closing filing to the court, because it captured, more precisely than any statute could, exactly what the entire scheme had been built to exploit. Front 4 was political, and it was the one that took the longest to build and did the most damage in the end. Cheryl Anholt, the garden gnome fine, the 911 call, approached Rachel and Marcus about running a slate for the board at the next annual election. Still 8 months out, but suddenly, urgently relevant. She had spent 31 years managing rooms full of teenagers who thought they could get away with things, and she found she had, it turned out, considerable appetite left for managing one board president who thought the same thing. Priya Nandakumar, the mother with the wrongly fined wheelchair ramp, joined. So did a retired CPA named Harold Vance, no relation to Marcus's business partner, a coincidence the neighborhood found amusing for about a week, who had quietly noticed, 2 years earlier, that the association's reserve fund contributions didn't add up to the number Draper cited at annual meetings, and had never had the standing or the courage to say so out loud until now. The 4 of them met, for the first time as a group, at Cheryl Anholt's kitchen table on a Tuesday night in late April, and what struck Rachel most, sitting there with her cast propped on a dish towel, was how ordinary it all looked. A retired teacher, a CPA, a mother of 2, and a physical therapist with a fractured wrist, going through 3-ring binders of meeting minutes under a kitchen light, the way other people might plan a block party. Harold Vance had brought printouts of every reserve fund disclosure Brookstone Ridge had filed with the state since its incorporation, and within an hour had circled, in red pen, 4 consecutive years where landscaping invoices from a company called Greengate Grounds Management had increased by exactly 11%, a suspiciously tidy number for a business supposedly operating in a competitive market, and one that took Harold roughly 40 minutes to trace back to a business registration listing Draper's brother-in-law as managing member. Nobody in the room said the word fraud out loud that night. Nobody needed to. It was already written, in red ink, on the table in front of them. Priya Nandakumar's contribution to the effort was quieter but no less pointed. She had kept, for over a year, every piece of correspondence related to her son's ramp application, including the 2 rejection letters that cited aesthetic incompatibility with neighborhood character as grounds for denial, a phrase that does not exist anywhere in Ohio law as valid grounds for rejecting an accommodation request, and one that directly contradicted Federal Fair Housing Act protections requiring reasonable modifications for residents with disabilities. Denise Okonkwo-Barrett, reviewing the file weeks later, would call it one of the cleanest FHA violations I've seen from an HOA board in 15 years of doing this, a compliment that landed, in context, like a gut punch, because it meant a 10-year-old boy had been denied safe access to his own front door for 11 months over a rule that had never been legal in the first place. The coalition, as the Facebook group started half-mockingly, and then not mockingly at all calling them, did not need a recall election to force a reckoning, in the end, though they were fully prepared to run one. What they needed was a single board meeting where all 4 fronts collided at once, in public, on the record, and that meeting came on May 24th. Marcus and Denise just filed suit naming the whole board, not just Ironclad, a much bigger swing than most people would have made. Was that the right call? What's your strategy? The clubhouse community room at Brookstone Ridge seated 60 people comfortably. On the night of May 24th, 94 showed up, plus a stringer from the Fairview Courier-Journal who had gotten wind of the assault charge 2 weeks earlier and had been quietly filing public records requests of his own ever since, and a 2-person crew from the local NBC affiliate who set up a camera in the back corner with Gary Draper's grudging, board by law mandated permission, since Ohio's open meeting expectations for association business made refusing them look considerably worse than allowing them. Draper opened the meeting, attempting the same tone he'd used in March, measured, faintly condescending, a man confident the room still belonged to him. He got through the approval of February's minutes and a discussion of pond aeration costs before Harold Vance, the retired CPA, stood up during new business and asked, politely, whether the board could explain a $41,000 discrepancy between reserve fund contributions reported at the previous annual meeting and the actual bank statements he had obtained through a records request the week prior. Draper said the figures were being reconciled. Harold Vance said he had the statements printed. Would the board like copies? And passed forward 11 of them before anyone could stop him. Denise Okonkwo Barrett spoke next, not as an attorney addressing a jury, but as an attorney addressing a public board meeting she had every right to attend as her client's counsel, and she read, slowly and without embellishment, the language of Section 7-B of the ironclad contract, followed by Draper's police statement claiming no financial stake existed, followed by the 30% contingency invoice with Draper's own initials on the approval line. The room, which had spent the first 20 minutes in the particular restless quiet of people who came for a spectacle and weren't sure they'd get one, went fully silent. Then Priscilla Odom's office weighed in. Not Priscilla Odom herself, who does not attend HOA board meetings, but a letter, hand-delivered that afternoon, and read into the record by Denise at Rachel's request, confirming that the Ohio Attorney General's Consumer Protection Section had opened a formal investigation into Brookstone Ridge HOA's fine collection practices and its relationship with Ironclad Compliance Solutions, LLC. Gary Draper, at this point, made the mistake that ends a great many HOA board presidencies. He got angry, on camera, in front of the one reporter in Fairview County who had spent 2 weeks building a story. He said, among other things, that this is exactly the kind of witch hunt that happens when you let one loud family turn a community against its own leadership, a sentence that made it, verbatim, into the 10 o'clock broadcast that night, right after a clip of Marcus Doyle, filmed calmly, standing, not raising his voice, saying, "My wife has a permanent scar above her eyebrow from a man your board hired and paid to enforce a fine that violated your own published fine schedule. I'd like the board to explain that to the room, on the record tonight." The room did not stay quiet for long after that. An elderly homeowner named Frank Pelletier, who had lived in Brookstone Ridge since it was built, and had, by his own account, never said a word at one of these meetings in 26 years, stood up and asked Draper, directly, whether he intended to reimburse Cheryl Anholt for the garden gnome fine, given that no such violation existed anywhere in the governing documents. Draper said the matter was under board review, a phrase the room had apparently heard enough times to recognize as meaningless, because it drew an audible groan from at least a dozen people. A woman near the back, never publicly identified, though the NBC affiliate's footage caught her clearly, shouted, "Just say sorry, Gary," which got a ripple of laughter that was not kind and was not meant to be. Denise Okonkwo Barrett closed her portion of the meeting with a single request, addressed not to Draper but to the room as a whole. She asked that the board formally table any further collection action on the Doyle's trailer fine, pending the outcome of litigation, a request the remaining board members, down 2, with Phil Okafor and Tricia Lund having already resigned into the record, voted to approve, 3-0, without discussion, in what may have been the fastest unanimous vote in the association's 26-year history. Rachel did not speak at the meeting. She had told Marcus and Denise beforehand that she didn't need to, that she'd already said everything she needed to say to a police officer, a doctor, and a courtroom filing, and that she would rather sit in the third row with her healing wrist in her lap and watch the room finally hear it. She would say, later, that watching Phil Okafor's hands shake as he read his resignation into the minutes was the first moment in 2 months she'd felt something loosen in her chest. Draper could not explain it. Nobody at the table could. 2 of the 4 other board members, a soft-spoken dentist named Phil Okafor, no relation to the responding officer, and a woman named Tricia Lund, who had joined the board 18 months earlier and had, it turned out, been quietly uneasy about Ironclad's invoices for months, resigned on the spot, verbally, into the meeting minutes, effective immediately, before the meeting had even formally adjourned. It is, incidentally, exactly the kind of moment this channel exists to document. A board that spent years assuming no one was paying close enough attention to catch them, discovering in real time, in front of a television camera, that someone finally had. After everything Rachel and Marcus went through, the assault, the lien threat, the neighborhood turning against them before it turned back, was it worth it? Have you ever fought your HOA and won, or walked away? Tell me your story in the comments. The reckoning did not end that night, though the night made it inevitable. Wade Pruitt pleaded guilty 5 weeks later to assault and to the impersonation charge, in exchange for a recommended sentence that included 90 days in the county jail, 2 years of probation, restitution to Rachel Doyle covering her medical expenses and lost wages, and a condition Denise had specifically requested and the judge had granted without hesitation, a permanent prohibition on Wade Pruitt operating, owning, or working for any residential compliance, code enforcement, or property management company in the state of Ohio for the rest of his life. Denny Osick, who had not touched Rachel but had stood by and done nothing, took a lesser plea and a fine of his own, which several people in Fairview found the funniest detail in the entire saga. Rachel attended the sentencing hearing herself, cast long since removed, though she still, at the time, wore a compression sleeve on her left wrist during long shifts at the hospital. She gave a victim impact statement that ran under 2 minutes, shorter than almost anyone in the courtroom expected, from a case that had, by then, been covered by 2 local news stations and picked up briefly by a regional wire service. She did not mention Marcus's service record. She did not mention the Navy at all. She talked instead about her patience, about the specific, quiet indignity of teaching someone twice her age how to trust their own body again after an injury, and what it had cost her, professionally and personally, to spend 8 weeks unable to model the very exercises she prescribed. I have spent my whole career telling people that healing is possible if you're patient and you do the work, she told the courtroom. I would like the record to show that I did the work. I would like the record to also show that I shouldn't have had to. Wade Pruitt, seated at the defense table in a borrowed sport coat, did not look up during any part of it. The judge, a longtime Fairview County jurist named the Honorable Marion Castellano, added one further condition to the sentence that had not been part of the original plea agreement: a formal written apology from Wade Pruitt to Rachel Doyle, to be entered into the court record rather than delivered privately, on the grounds, Judge Castellano said from the bench, that a public assault committed under color of false authority deserves a public accounting, not a quiet one. The apology, 2 paragraphs long, was read into the record by the court clerk. Rachel has said, in the years since, that she has never once reread it, and does not intend to. Ironclad Compliance Solutions, LLC, was dissolved by its own registered agent within a month, once its sole client discovered exactly how much civil exposure came attached to a contingency fee enforcement scheme run by 2 unlicensed men with a laminated badge from a print shop. The civil suit against the Brookstone Ridge HOA settled before it reached trial, for an amount neither side was permitted to disclose publicly, though Cheryl Anholt would later note, with the satisfaction of a woman who had waited a long time for this particular sentence, that the association's insurance carrier had asked some very pointed questions about board oversight before agreeing to cover any of it. Gary Draper did not wait for a recall vote. He resigned as board president on June 9th, in a 2-line email to the remaining board members that made no mention of the assault, the lien, the contingency fee, or the $41,000 reserve fund discrepancy the state's investigation would ultimately trace to 3 years of inflated landscaping invoices submitted by a contractor who happened to be Draper's brother-in-law, a detail that surfaced 4 months later. well outside the frame of this particular story, but confirmed, for the record, in the Ohio Attorney General's final report, which resulted in Draper being referred separately for potential theft in office charges related to the association's funds, a matter that was, as of this telling, still working its way through the county prosecutor's office. In the weeks between Draper's resignation and the November election, the interim board, Phil Okafor's and Tricia Lunn's replacements appointed on a temporary basis under the association's bylaws, hired an independent forensic accountant to comb through 3 years of Greengate grounds management invoices at Harold Vance's specific, insistent request, a step Harold had been asking for, informally, for nearly 2 years before anyone with actual authority was willing to listen. The accountant's preliminary findings, shared with the full board in October, confirmed what Harold's red pen had already suggested. Landscaping costs at Brookstone Ridge had been inflated by an average of $9,400 a year for the preceding 3 years. Funds that had, in practice, quietly padded a reserve account Draper controlled discretionary access to for association promotional expenses, a line item that had, among other things, covered his own registration fees at 2 out-of-state HOA leadership conferences. The annual election that November did not need to be a recall fight. It was, instead, something Brookstone Ridge had genuinely never seen: a contested board election with real turnout, real candidates, and a slate: Cheryl Anholt, Priya Nandakumar, and Harold Vance, running not on vengeance, but on a platform so specific it read almost like a legal brief. Mandatory bonding and licensing requirements for any future compliance contractor, a public, annually published fine schedule with no retroactive penalties, mailed notice with a full cure period for every first violation, quarterly published financial statements, and term limits for the board presidency, capped at 2 consecutive years. All 3 won. Turnout was the highest in the association's 26-year history, driven in no small part by a Facebook group that had, over 8 months, transformed from Gary Draper's personal echo chamber into the single most engaged homeowners association page in the county. Rachel Doyle's wrist healed fully by August, with one small permanent flat spot in her range of motion that she says she notices only when the weather changes. She went back to work full duty in July, and that same month, quietly returned to teaching the same wrist rehabilitation protocol to her own patients that she had, for 4 months, needed herself. The chipped tooth was repaired in a single dental visit, and is, per Rachel, genuinely the least interesting part of this whole story, but everybody asks about it anyway. Patriot Build Co. finished Eldon Frey's ramp on a Saturday in late April, 6 weeks later than planned, with Marcus, Doc Reyes, and Alan Vance doing the work themselves on a weekend Rachel's wrist was still in its hard cast, while she sat on Eldon Frey's porch in a lawn chair, one-handed, handing tools up when they were needed and taking a picture, at the end of the day, of a 71-year-old Marine Corps veteran rolling down his own front ramp for the first time in over a year, under his own power, no help required. That photo, not the driveway assault footage, is the one Rachel keeps as the wallpaper on her phone. Brookstone Ridge Homeowners Association is, today, run by a 5-member board with a 2-year term limit on the presidency, a published fine schedule available to every homeowner without a records request, and a vendor vetting policy, adopted unanimously at the first meeting of the new board, that requires any third-party compliance or enforcement contractor to carry a state business license, professional liability insurance, and a written, board-disclosed compensation structure with no contingency fee arrangements permitted, period. Cheryl Anholt currently serves as board treasurer. She still keeps garden gnomes on her front lawn. Nobody has fined her for it since, and, per multiple accounts from the neighborhood, nobody is planning to try. Priya Nandakumar's son's ramp, the real one, the one that had cost her $1,200 in wrongful fines before it was ever approved, was retrofitted, at the association's expense as part of the civil settlement, with a covered awning the family had wanted from the beginning but never dared request. Harold Vance's red-penned reserve fund discrepancy became the seed of a separate, ongoing state audit into Greengate Grounds Management's contracts with 3 other homeowners associations in the county, a matter the Ohio Attorney General's office confirmed was active as of this telling, but declined to comment on further. Kurt Belanger, the man who wrote the comment about Marcus playing soldier, sold his house on the far side of the pond that following spring and moved out of Brookstone Ridge entirely, a departure the Facebook group noted with considerably less sympathy than it had once reserved for Gary Draper. Marcus Doyle went back to running Patriot Build Co. full-time, and the organization, which had built 4 ramps in its first year, built 11 in the year following the case's resolution, after a local news segment about the Doyles' fight brought in a wave of donations neither Marcus nor his 2 co-founders had anticipated. He still does not like talking about the assault on camera, and he agreed to the one interview he gave, largely because Rachel asked him to, and largely because Eldon Frey, the Marine Corps veteran whose ramp started the entire chain of events, asked to be in the room when he did it. Frey, for his part, has said publicly and often that he considers the ramp outside his front door the most expensive 30 feet of lumber in the history of Fairview County, a joke that gets a genuine laugh out of Marcus every single time he hears it, which by his own count is now well over a dozen times. Rachel Doyle keeps one other memento from the case, alongside the photo of Eldon Frey rolling down his ramp, a printed copy of the final page of the Ohio Attorney General's investigative summary, the one that concluded, in the flat, understated language of government findings everywhere, that Brookstone Ridge Homeowners Association had engaged in a pattern of fine assessment inconsistent with its own governing documents, facilitated by an unlicensed and improperly incentivized enforcement contractor. She keeps it not out of vindictiveness, she says, but because it is proof, official, state-issued, undeniable proof, of something she already knew the moment she hit the driveway with a split lip, that she had not, in fact, been the unreasonable one. Marcus Doyle still lives at 1847 Timberline Court. He still parks a Patriot Build Co. trailer in his driveway when a project calls for it, sometimes for longer than 24 hours, and no one, not the board, not a management company, not a man in a laminated badge, has said a word about it since. He says he doesn't think of what happened as a war he won. He thinks of it, when he thinks of it at all, as a checklist he ran the same way he ran every checklist for 22 years. Gather the facts, verify them twice, and let the truth do the work it was always going to do, given enough time and enough documentation. Rachel puts it more simply. She says the thing nobody tells you about fighting an HOA is that you're never really fighting the board. You're fighting the assumption that no one is watching closely enough to stop them. Brookstone Ridge learned, the hard way, that someone finally was. If your HOA is doing something you think crosses the line, a fine that doesn't match the schedule, a contractor who shows up without a license, a board that won't show you the books, document everything. Know your state's statutes by name, and remember that the people who count on you never checking are usually the people with the most to hide. If this story hit close to home, subscribe to HOA Horror Files, because there is always another Gary Draper out there, in another subdivision, counting on nobody ever finding out.